That's right, she's back. The world's Trumpiest judge, Judge Eileen Cannon, is back, and this time it's to preside over the criminal case against Donald J. Trump over his hoarding of national defense information in the Southern District of Florida. Judge Cannon was the Trump appointee who intervened in the documents case by accepting jurisdiction where none existed to put up roadblocks against the government's investigation in the pre-indictment stage. Her rulings were so bonkers that the conservative 11th Circuit Court of Appeals took the case away from her because she defied, quote, our nation's foundational principle that our law applies to all without regard to numbers, wealth, or rank. But now that Judge Cannon is back on the case, is there anything that prosecutor Jack Smith can do about it, or is he about to become cannon fodder? But first, my eaglets, we need to think like a lawyer and figure out how we got here in the first place. Now, after the FBI served a search warrant on Mar-a-Lago, Trump filed a lawsuit seeking the appointment of a special master over the proceeding. You might recall that Trump filed the suit in the Fort Pierce division of Florida, even though Mar-a-Lago is in the West Palm Beach division, because he wanted Judge Cannon to preside over it. Judge Cannon agreed with Trump that a special master should be appointed to review over 11,000 documents and 1,800 items that the FBI seized. She also took the extraordinary step of, quote, temporarily enjoining the government from reviewing and using the seized materials for investigative purposes, pending completion of the special master's review or further court order. Her order effectively halted the government's criminal investigation, and the government appealed it in its entirety. The government also filed a separate motion to stay the part of the ruling that stopped the FBI from looking at the 103 documents with classified markings. Judge Cannon denied the DOJ's motion, rejecting the government's argument that Trump couldn't assert executive privilege or any other interest in the documents with classified markings. Judge Cannon also refused to accept that the documents marked classified were necessarily classified. Come on, Eileen. I swear at this moment the DOJ appealed, and in September the 11th Circuit issued a partial stay of her order prohibiting the government from reviewing documents marked as classified. The unanimous opinion thoroughly rebuked Judge Cannon for her ruling, saying, quote, we cannot discern why plaintiff would have an individual interest in or need for any of the 100 documents with classification markings. And in December, the 11th Circuit found that Cannon never should have exercised jurisdiction, and the panel vacated Judge Cannon's order, excoriating her for implying that special rules apply to Trump. Quote, we cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant, nor can we write a rule that allows only former presidents to do so. This was a fancy way of saying that Judge Cannon was not acting as she should have.
You know you done f***ed up, right?
It truly was an extraordinary opinion from a panel of conservative judges against one of their own. So now, Judge Cannon's assignment as trial judge has some people wondering if the process is rigged.
We have a rigged country.
Now, under the district court's procedures, new cases are randomly given to a judge who sits in the division where the matter arose or a neighboring one. Now, the New York Times asked Angela Noble, the chief clerk of the Southern District of Florida, whether normal procedures were followed and whether Judge Cannon's assignment was random. She said, quote, normal procedures were followed. Now, Noble explained that Mar-a-Lago is in the West Palm Beach division between the Fort Lauderdale division and the Fort Pierce division where Judge Cannon sits. The district court's website shows that 7 active judges have chambers in those 3 divisions, as do 3 judges on senior status who still hear cases. Now, Noble said that certain factors increase Judge Cannon's chances. Quote, for one, senior judges are removed from the case assignment system, or wheel, once they fulfill their target caseload for the year. At least one of the senior judges is done. And she added that, quote, she was highly confident that the other 2 are very likely at their target too. Furthermore, she went on to say that one of the 7 active judges with chambers in Fort Lauderdale is now a Miami judge for the purposes of assignments, and another is not currently receiving cases. But what about Judge Middlebrooks, who earlier this year ordered Trump to pay nearly $1 million for filing a frivolous lawsuit against Hillary Clinton? Noble said that Judge Middlebrooks draws 50% of his criminal cases from the Miami division, and that decreased his odds. In contrast, Judge Cannon, quote, draws 50% of her cases from West Palm Beach, increasing her chances. So there you go. Sometimes things can be random and fate just has a sense of humor.
Happy Hunger Games, and may the odds be ever in your favor.
So let's talk about how and when judges who are assigned can be disqualified. Now, judicial impartiality is one of the bedrock principles of the rule of law. Litigants have a 14th Amendment right to a, quote, neutral and detached judge. And when a party believes that a judge may not be impartial, the remedy is to move to disqualify the judge from the case. Now, the primary source of disqualification is 28 U.S.C. 455, which says in relevant part, quote, any justice shall disqualify himself in any proceeding in which his impartiality might reasonably be questioned. He shall also disqualify disqualify himself in the following circumstances. One, where he has a personal bias or prejudice concerning a party, or personal knowledge of disputed evidentiary facts concerning the proceeding. Now, the standard for disqualification is whether, quote, a reasonable objective person knowing all the circumstances would have questioned the judge's impartiality. And many people say that the 11th Circuit's smackdown of Judge Cannon proves that she is biased in favor of Trump. Now, the implication in the 11th Circuit's ruling was that Cannon made up a rule that would let the cranky ex-president stop a criminal investigation because of personal favoritism. But that's not necessarily evidence of personal bias. The Supreme Court has held that, quote, judicial rulings alone almost never constitute a valid basis for a bias or partiality motion. The Supreme Court also said that, quote, judicial remarks made during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties or their cases, ordinarily do not support a bias or partiality challenge. So even if the judge made a ruling that was overturned on appeal, and even if the judge made remarks that were hostile to the government's case, that isn't necessarily enough to warrant recusal on its own. And the Supreme Court also said that, quote, judicial remarks made during the course of a trial that are critical or disapproving of or even hostile to counsel, the parties or their cases, ordinarily do not support a bias or partiality challenge. So even if the judge made a ruling that was overturned on appeal, and even if the judge made remarks that were hostile to the government's case, that isn't enough to warrant recusal on its own. But on top of that, as many people have pointed out, Judge Cannon was appointed to the bench by then President Trump. Does that form the basis of a motion to disqualify? Well, the Supreme Court has never ruled that a federal judge should be disqualified from ruling on a matter that involves a president who appointed them. Federal judges, in fact, hear all sorts of cases involving the actions of the president or their administration, although usually those matters involve the legality of the president's legislative or executive actions and not whether the president individually should go to prison or not. Now, if you ever find yourself in a lawsuit dealing with an unreasonable judge, you're definitely going to need a great lawyer. And it's great news because my firm, the Eagle team, is now accepting new clients. If you've ever been in a car crash, suffered from police brutality or sexual harassment, or just about anything else, we can represent you or help find the right attorney who can. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. So just click on the link below. Now back to Judge Cannon. Now, Judge Cannon could recuse herself sua sponte, meaning on her own volition, if she wanted to. But let's assume that she decides to remain as trial judge. Could the case be reassigned anyway? Some commentators, including former U.S. Attorney for the Northern District of Alabama, Joyce Vance, thinks that that's the case. She points to a case called U.S. versus Martin, in which the 11th Circuit ruled that even though there was no indication of actual bias, a criminal case should be reassigned to a different judge. In that particular case, the court had to reverse the trial judge's sentencing determination twice. The court said that it also reversed that judge in 3 other cases for, quote, extraordinary downward departures that were without a valid basis in the record. So in light of this prior action, the Court of Appeals felt that the judge would have difficulty putting his previous views and findings aside. And that seems to fit with most of the times that the Court of Appeals tends to intervene. It's repeated misconduct from a particular judge. And the 2 times that Judge Cannon has been rebuked by the 11th Circuit in this particular case are pretty individualized and may not rise to that particular standard. And of course, it's possible that Jack Smith and the Department of Justice could move to disqualify Judge Cannon.
I'm going to request that you disqualify yourself from sitting on this case. I'm going to take a transcript of the trial to the Judicial Conduct Board and ask that they impeach your ass.
Generally speaking, the Department of Justice is loath to try to kick judges off of their cases because they are repeat players and they don't want to piss off any particular judge they might be in front of again. Though at the same time, this might be one of those cases where they want to roll those dice. So the next question is, if Judge Cannon remains on the case, how much power would she have here? Well, the answer is a lot. Now, Trump would obviously prefer to delay the proceedings as long as possible until he is potentially elected president again, and might pardon himself. And Cannon can play along with that plan quite a bit if she wants to. In an extreme case, Judge Cannon can also just dismiss the case before trial. And of course, there are a million different pre-trial decisions that a trial judge has to make before it gets to trial. For example, there's bound to be a fight over the use of Trump's attorney's notes, which contain communications between Trump and his attorney, which of course were allowed to be used in the run-up to the indictment because another court found that the crime fraud exception applied and breached the attorney-client privilege. And if Judge Cannon ruled to exclude this or any other kind of evidence, the standard is extremely favorable to the trial judge. Effectively, the government would have to prove that the judge abused their discretion in disallowing the evidence, and that's a really high burden to get over. And if she lets the trial go ahead, Donald Trump could file for a Rule 29 motion that would allow the judge to enter a judgment of acquittal if the judge believed that the evidence was insufficient to sustain a conviction, and that ruling would be unappealable, and double jeopardy would attach. The judge can do this at the close of the government's evidence after the jury makes up its decision, or for up to 14 days after a guilty verdict. Though if she acquitted Trump after the jury found him guilty, the government might have a limited right to appeal, but only on the issue of whether there should be a new trial. And in terms of real punishments for malfeasance from the judge in this kind of a situation, the options are really slim. Judge Cannon has been appointed to the federal bench for life, and she can only be removed through impeachment in the House and conviction in the Senate, which is obviously extraordinarily rare. Though there is another option. Trial judges generally hate being reversed by the Court of Appeals, and it's possible that after being rebuked by the 11th Circuit twice, Judge Cannon has learned her lesson and will play this one straight. It's also possible that seeing the allegations and the evidence before her in this particular case, she would play it more straight ahead than what she did in the prior pre-indictment case itself. But given the prior shenanigans that we saw, I wouldn't necessarily hold my breath on that particular take. Additionally, Florida isn't the only jurisdiction that could hear the documents case. Federal prosecutors are required to present cases for indictment in the district where the alleged offense occurred. In the documents case, there was relevant conduct that occurred in Washington, D.C. and Bedminster, New Jersey, as well as Florida, though obviously most of it happened in Florida. And venue in Florida makes sense because the majority of the action took place there, and prosecutors probably picked Florida to avoid a fight with Trump over proper venue. However, Prosecutor Smith could still bring a documents case in potentially Washington, D.C. or New Jersey, as some of Trump's conduct did happen in those locations as well, if there are additional crimes that have not yet been charged. But the bottom line is that Cannon is going to need to find her voice. Is she going to issue lawless, crazy rulings like in the Warren proceedings, or act like a normal, sane judge? And she can do that with today's sponsor, Skillshare, and particularly Nathaniel Drew's great class, Creativity Unleashed, Discover, Hone, and Share Your Voice Online. Nathaniel's one of my favorite online creators, and in his Skillshare class, he'll guide Judge Cannon through determining her individual value as a creator, overcoming insecurities, establishing her core theme, and evolving her work as she grows. All important lessons for a federal judge or anyone looking to explore their own creative and career goals. Skillshare, as you probably know, is one of the world's largest online learning communities with tens of thousands of classes on almost everything. You may know Skillshare for their classes in photography, film and video editing, and illustration, but they also have hundreds of career-focused classes as well. So if you'd like to try out Skillshare, the first 1,000 legal eaglets to use my link in the description will get a free trial of Skillshare Premium. And for a limited time, that trial is for an entire month, not just 14 days as usual. All you have to do is click on the link on screen or down in the description. So for a free 1-month subscription to Skillshare, just click on the link below. And then after that, click on this link over here for more Legal Eagle, where I'll see you in court.